All right, so hey everybody, we will start class today with start a discussion about employment law today. So this class is interesting. It's usually changing about every time I teach this. I have to go in and update information about, for example, minimum wage is always in flux. Um, Later this week, so this whole week is really employment law. I divided it up into employment law, discrimination, and harassment, although it's really just employment law. And yeah, so with this class, I think we'll focus on just some general things and then save yeah, kind of the specifics with harassment and discrimination for later classes. Interestingly enough, if you've been following me on Twitter, you've seen that last week the Supreme Court changed something in our textbook about discrimination, and especially with sexual orientation and identity. So that is something I haven't done it yet, but I'm going to have to go rewrite that chapter on discrimination, thanks to that new Supreme Court ruling, like I said, just last week. So you can see that this is in flux quite a bit. All right. When it comes to, oh, and I should say, because I do this every Monday when this happens, welcome to exam week. So this Friday and Saturday, you can take your exam. It'll cover intellectual property and yeah, it's primarily intellectual property, bankruptcy, secure transactions, and employment. So yeah, that'll be this weekend. I will do another study session. I'll just create, once I'm done writing the questions, I'll do a study session and I'll just post that on YouTube for you as well. Otherwise, we'll meet all week. So Monday, Wednesday, and Friday to here in Zoom. Okay, so that's it for announcements. All right, let's do this then. So when it comes to employment law, the key and the most important thing, you probably saw this in the reading, is the U.S. basis for employment law, the foundational. Yeah, it's really a foundational structure of U.S. employment law is this idea of employment at will. And I think the easiest way to understand this is that you can fire somebody for any reason at any time. And this differs substantially from the European model, which is based on contracts for time and more employment stability is one way to say it. Red tape is another way to say it if you're American. Here, we just want to be able to clear the way to fire people as quickly as possible, focus on efficiency and yeah, the ability to hire people quickly and fire them quickly as well. Now, there's a flip side to this as well. In the US, you can quit at any time. And this is always interesting because many of my students think like, well, Brother Hales, you can't do that. You have to give 2 weeks notice. No, you don't. Like, you can just leave. You're sick of it one day, just pack your stuff and walk out. And you can do that legally in the US. Unless there are exceptions to everything that I've said so far, which of course there are exceptions. It's US law, and you're used to this by now. You've studied statute of frauds, so you understand. We'll get to the exceptions here in a minute. But again, the foundational lesson here is just that you can fire anybody at any time, and you can quit at any time. Now, for those of you that are wondering if you should quit and make a scene, yeah, technically you may have legal rights to do that, but that's going to hurt your ability to get a good reference, and you're burning bridges. And so I don't recommend it. I do recommend giving 2 weeks notice. Okay, just so we're clear on that. And the same if you're an employer. Through the most recent economic downturn in 2020, uh, many employers received high praise in their willingness to work with employees instead of just firing them, as they have the right to do, and saying, pack your things, today's your last day. Many businesses were incredibly smart about this and gathered everybody together and said, this is our economic situation. We've got some plans, but we'd like some input. And with a lot of these businesses in the financial sector, is what I'm thinking of right now, everybody took like a voluntary 20% pay cut. Why? Because if they didn't, then Bob was going to lose his job, or Sue was going to lose her job. And by everybody working together, they were able to save jobs and kind of weather the worst of it. And so again, just because you have the legal right to do something doesn't mean you should. And I would encourage all of you to kind of look for creative ways to work around financial difficulties, because again, people losing their jobs, and many of you have seen this. Your parents, you were young during the last recession 10 years ago, but many of you saw your parents lose jobs, and you probably saw how difficult that was for them. And so again, this is just my plea for some semblance of maybe decency, although I understand it's not always possible. Sometimes it's vital and necessary for the survival of the business to fire people, but oftentimes there's different ways to do this that show more empathy and sympathy to the workers. And same for most of you, you're not going to be hiring people right out of school. You will be applying for jobs. And so do be courteous. Don't burn bridges right off the bat. And so again, this is the most common employment scheme in the United States, is at will. But there are exceptions. So let's go through a few of these, because these can be very interesting. And sometimes employers think that their employee is an at-will employee, and so they want to fire them. And it turns out that they're not. And so kind of the way to think about this, I think big picture, is that in the US, most workers are at-will employees, meaning you can hire them, or mostly meaning you can fire them for any reason. And this is going to be important, especially when we get to discrimination. You can fire somebody for any reason, unless it's a prohibited reason. Now, discrimination is going to be one of those. So we'll get to that next class period. But this slide has a list of other reasons that you might not be able to fire what you may have thought was an at-will employee. Okay, and so the major one is going to be contracts. And now that you're well versed in contract law, this will make sense. But we've also got torts and public policy arguments as well. So the contract theory is just this idea that maybe when the employer and employee entered into this working relationship, that at-will employment scheme was modified through contracts. And again, look for contracts through the main elements: the offer, the acceptance, and the consideration. If that happens, then the employee can't be fired for any reason. Maybe the contract theory created a reason that, or a new scheme whereby the worker could only be fired for just cause, meaning for cause, meaning like, well, it's just added protection that we'll talk about in a second. So I think one way to look at this is, well, let me do this. Let me just go through these one at a time, right? Because I do think this is important that you understand in more detail. With contract theory, let's say that I hire you. I hire Trent. You're at the top of my screen, so I'll pick on you here a little bit. I hire you to work at my, it's summer. Let's say I'm hiring you to work at my snow cone business. and you're the um, snow cone operator. Well, one day Trent comes into work, and Trent, if you don't mind, you can unmute yourself. Trent, what's your favorite food in the world?
My favorite food is pizza.
All right, all right. So Trent likes pizza, right? And let's say that I hate pizza. I hate everything about pizza. I hate Italians. Like I am legit a terrible person, right? And so Trent comes into work every day smelling like pizza. Okay, good gracious. Sorry, there's an Amber Alert, and so some of you, if you're on Sprint, you may be getting this in a second too. All right. So Trent comes to work every day smelling like pizza. Well, I'm the most anti-pizza person in the world, and so Trent, if you walk in one day smelling like pizza, and let's assume nothing else here, other than you're an at-will employee, do you think I can just fire you for smelling like pizza?
Yeah, if I'm an at-will employee.
Yeah, yeah. So again, I can remember at will means I can fire for any reason, except a prohibited reason, and um, and so yeah, absolutely, I can fire Trent because he smells like pizza, and I can tell him that's the reason that I'm firing him. I'm going to say, Trent, you smell like pizza. Again, I hate you. Get out of here. And can I do that? You bet. Absolutely. Trent's gone. Unless maybe Trent, when you signed up to work at my snow cone rest not restaurant hut or whatever it is, the snow hut, maybe you signed an at will contract, but let's say that after you signed it and you worked there for a year, let's say that I sent you a text or an email that says something like, Trent, you're invaluable to my business. I just want to let you know that I won't ever fire you unless the company is going out of business or we're in dire financial straits. And I shoot that off to Trent. And then the next day he comes in smelling like pizza and I fire him. Now all of you are probably thinking, okay, Brother Hales changed the terms of the agreement and we're allowed to do this. You're allowed to modify a contract at any time. The statute of frauds isn't gonna change that, and the parole evidence rule. Like you can go through all of those things that you learned in week 4, 5, and 6 to come to the same conclusion. I can't fire Trent for smelling like pizza right now. Why? Because our contract altered the original terms of our agreement. So again, we look at the reasonable expectations of the employee. Like whatever I say or write or text or whatever to Trent, we're going to look at his reasonable expectations. And if it's reasonable for him to assume that he's no longer an at-will employee, then we've changed it based on contract theory. No longer an at-will employee. I can't smell him. I can't fire. I can't smell you. Jeez. All of a sudden, I'm Joe Biden. I can't fire you for smelling like pizza anymore. Okay, so all right, contract theory. Tort theory just says tort theory is interesting. It doesn't mean you get to keep your job. It's just that if I fire you in an abusive way, um, one that is likely to cause severe emotional distress, for example. Well, then again, it's not that you get your job back, but it's that I went about the at will firing in the wrong way, and you can sue me for that. Basically, you can sue me for the emotional distress or fraud or um, uh, defamation, perhaps. So in this example, let's say, Trent, I'm just going to keep picking on you here. You come in to work. Again, you're an at-will employee. I haven't changed it under our new hypothetical here. But when you come in, I say something like, "Dang it, Trent! Um, I, I just hate that I have a racist working for me, and I know what you did. You went and you tore down that Martin Luther King Jr. statue. and because you're such a racist, you're fired. All right. Well, it turns out none of that's true. Trent is not a racist. He didn't tear down any statues. He's just, I'm just being a jerk here. I'm defaming him. And remember, for defamation, it has to be published to a third party. So it's not just me talking to Trent. It's me doing this over the loudspeaker. I have a huge snow shack, by the way, a snow cone shack, and all 50 employees hear me deriding Trent for this alleged racism that doesn't even exist. Well, yeah, Trent's not going to even want his job back, but he's going to sue me for defamation, intentional infliction of emotional distress. All of these things are going to give rise for damages to Trent. Because why? Yeah, he may be an at-will employee, but that doesn't mean that I can defame him while I am firing him. And so that's how Trent wins that case. Again, you don't get a job, but you're going to get 50 grand in damages. So,
Brother Hales, I have a quick question. So going back to the pizza, where scenario where you fire him because he smelled like pizza, you said that in that case you hated Italians, so you hated the smell of pizza.
Yes.
Wouldn't that be considered discrimination? And can't you not fire someone for like the race or ethnicity, even at employees?
Yeah, that's a great question. And so if Trent is Italian, then we've got some issues there, right? But if it's just, I hate the smell of pizza and Italians, but Trent is clearly Moroccan or something, like just something not Italian, well then I'm probably okay. I could even yell to the heavens and tell everybody I hate Italians. But Luigi, your job is safe. Trent, get out of here. You smell like pizza. Right. And all of that was wrong, what I just did. But nonetheless, it doesn't give rise necessarily to a discrimination claim. So, but that's such a good question, because when we talk about discrimination on Wednesday, you'll see that employers tend to not be complete idiots when doing their firing. That they may fire Luigi. Sorry, that's like the most Italian name I could come up with off the top of my head. They may fire Luigi, but they're going to say, it's because your work performance hasn't been great here, Luigi, and so get out. And they'll crouch their discrimination with some other reasoning. And for the reading on Wednesday, you'll see how you can still win these cases, even when the employer is lying as to the reason that they're firing somebody. You can still win that case. And so, yeah, it's an awesome question. So we'll get into that a little bit more, but yeah, I'm glad you asked that.
So
yeah.
Brother Hales, so let's kind of say, because this is on the emotional distress part of it, like, so let's say you decide to fire Trent for smelling like pizza, and you want to make a show out of it. And so you get everyone in the company together, and you have like a whole bunch of pizzas, and you're like, and you've just seen The Office, that episode in The Office where Kevin gets fired the day before. So you got Trent a special pizza with "you're fired" written on it in pepperoni, and you open it and hand it to Trent in front of everyone. Would that open you up for a lawsuit?
I think definitely there's a possibility. Now, we have to look at, with this tort theory, would the average reasonable person suffer emotional distress because of the way that the firing was done? Now some of you are like, well, every firing is going to cause emotional distress. True. So for the tort of wrongful termination, you have to show that this goes beyond that. It's not just you're fired, pack your things. We can do that. President Trump made a show out of this. Like, you're fired. Now, what you can't do is add on from there to the extent that it's going to cause that additional emotional distress. So just know on the exam, I'm going to make it very obvious. Like, not only are we going to fire them, but like Daniel was talking about, maybe we have like a fired tunnel and everybody has to go, like all the non-fired workers line up in the tunnel, and the fired person has to go through, and everybody like whispers to them like, you suck, like you're lame, get out of here, or something as they go by, like something that just goes beyond the pale of human decency and is meant to abuse and inflict that additional emotional distress on somebody. So yeah, that's what you're looking for. Okay. So
Brother Hales,
yeah.
super quick.
Huh?
Aren't there states that there are certain states when you fire somebody, you have to give them a reason why. And then there are certain states where you can fire somebody and give no logical reason as to why. And so like, even if it was discrimination, you don't have to tell them that. But if you did tell them that, then you would be in for a lawsuit. Are we going to cover that on Wednesday?
Yes. And yeah, but for now, just know that this is the general federal rule. States are allowed to change this. States can add additional worker protections. As you might imagine, it's Washington, it's California, it's DC. These are states and districts that are adding additional worker protections. That they have moved more towards the European model, whereas, like you may have guessed it, Idaho, not so much. Like we allow, in the state of Idaho, you can fire somebody for any reason whatsoever, as long as it isn't a prohibited reason. And so yeah, we'll get into more of those state differences here in a little bit. So yeah, the last exception here to the at-will doctrine is public policy. This is a very common one, and what it involves is just maybe you're firing somebody for wrong reason. Sorry, Preston, I'm muting you. And in this one, what happens is like maybe Trent, I'm going to fire you again. Sorry, I'm picking on you so much, but I'm going to fire Trent this time because he uncovered my accounting fraud. Maybe I'm a publicly traded snow cone company and I've been cooking the books, and Trent finds out about it. And so what do? I quickly fire him. Right. Well, there you can see the public policy has an interest in protecting the public from accounting fraud. And basically what Trent uncovered is he's going to be protected under the public policy of protecting the public. And so this gets into a number of whistleblowing statutes. These statutes exist and they differ from state to state as well. And they deal with when you can't fire somebody for protecting the public. Whistleblower statutes are notoriously confusing. Some states, meaning the state's whistleblower statute, requires you to go through the inside, like through the internal procedures of the company, meaning you have to talk to your supervisor. If your supervisor doesn't respond, then you have to go to the manager. If the manager doesn't respond, then you have to go to the VP. And if you don't do that, if you go immediately to the public, you may not be protected under the whistleblower statute of your state. Whereas other states say, sure, go straight to the press or go straight to the regulatory agency, the Commission of Corporations and Business for your state, for example. Do that first, or go straight to CNN and you're still protected. Others make you kind of jump through the internal hoops first. So this one, if you're ever in that position, it's going to be extremely important that you talk to an employer, or an employment law specialist, an attorney in that state, to figure out what it is that you have to do. Because if you go the wrong direction, there are plenty of people that have been allowed to be fired because they went to the press first. And California has more protections, more ability for employees to like seek redress inside and outside. And you've seen this. You saw Tyler Schultz, remember, with Theranos. He tried to bring it up directly to Elizabeth Holmes first, got shot down by Sonny. And that's why he ended up going to the Wall Street Journal, as well as regulators in New York, and he was protected under the way that he went. But in Idaho, you may not have as many protections, and so it's important to understand how you go about becoming a whistleblower before you just start blowing the whistle. And it depends if you're a public or private employee. You've seen, I mean, there's, what's his name, Snowden, who's hiding out in Russia now because there were state secrets involved in that one as well. So again, just cautionary tale, be careful. Let's see, Tirza, did you have a question?
Yeah, you kind of answered it with Snow. What do you do when it's like government secrets and it's obviously very wrong and in violation of like the public contract that you have with the people?
Yeah, with that one, you're gonna speak to an attorney. Now Snowden, he wasn't getting, I think he tried this at first, he just wasn't getting anywhere with like blowing a whistle internally with the CIA or the NSA, wherever it was that he was doing his advising at the time. And so that's why he went public, and again, basically blew up his life security to do what he felt was right. And anyway, lots of people applaud him for what he did. He's also public enemy number one in the minds of a lot of people. So again, if you're willing to sacrifice all of that, and it's that important, and you're not getting anywhere internally, and it would be illegal to go outside that chain, then you just have to make that decision. Yeah, good question there. All right. Okay, so now, again, if you fire somebody wrongfully, we're going to just call that wrongful discharge. When you sue your employer, it's called like the cause of action that you will bring against your now former employer will be wrongful discharge. Again, it's just an employer's termination of an employee's employment in violation of law or the employment contract. That's the definition of wrongful discharge. Now, this case right here is a case from, I think it's like 7 years ago now. Robert, he negotiated an employment agreement to work with MHS, that's the employer, as a consultant. MHS sent an offer, and Robert sent a counteroffer, again saying that he would work for $17,000 a month for 13 months. What we've done, what Robert did here was he changed the terms of the offer, and because the original offer was an at-will employment offer, and he said, nope, I'm going to add a term in here. I'm going to be a 13-month employee. And once you just know this, once you add that term, it means you can't be fired for any reason now. It means you can only be fired for good cause. And we'll get to that as well. But again, $17,000 a month for 13 months means you've got a term and you're not at will anymore. So MHS accepted. They wrote an email back and said, to the effect of, we accept, and Robert began working. Then MHS did what many companies do when they realized maybe they made a mistake or whatever. They said, look, that email wasn't an acceptance. It was just an agreement for us to start further discussions about what we're going to pay you. And it's a silly legal argument, but it's common. Yeah, Jeremiah.
I think we're all stuck on the first slide.
Oh, here, let me come back here. Okay, so let's try this again. All right, what are you seeing now?
Wrongful discharge.
Okay, so you can see that screen. Can you still see it?
Yes.
Okay.
Yeah.
Good. Okay, so this just has that slide with Robert and MHS. And again, knowing what you know now about contracts, you're going to say, well, sorry, MHS, you accepted. Like that's why we've got this MHS accepted via email statement in there. Oops. And so basically, MHS accepted it. Now they can't fire him for any reason. They've got a 13-month term, and that differs from employment at law. Because remember, at will. Employment at will means you can fire somebody at any time and for any reason. Now once you add a term on there, once you've got a year-long term or a 13-month or a 20-year term, you're no longer at will. And what that usually means is that during that term, you can only fire that person for good cause. So just wanted to show this case so you can kind of see what's going on with wrongful discharge. All right, now we get into this other kind of interesting stuff. My wife and I watched Jojo Rabbit not that long ago, so I've got a child actor up here. All right, and what's interesting here is in this graph that you're seeing right now, this is Idaho specific. So I actually went in, and you'll get a kick out of this. All right, so in general, children under 14, they're allowed to work, but it's kind of specific about what it is, what it is that they can do. For example, they can do paper routes. Those don't really exist that much anymore, unfortunately, but they can also work for parents, and they can work for the entertainment industry, hence the Jojo Rabbit character here. Now, kids under 14 are not allowed to do hazardous work. Right? And this, I always love this part of the class because I always have like 3 students in here that are like, well, my dad had me driving the tractor when I was 9. Is that okay? And the answer is no, your dad broke the law. So no, nothing hazardous. If there's a chance of you like falling off and getting cut to pieces, then that's called hazardous work. And so there you have it. So no hazardous work under 14. Although, like I said, many of my students that grew up on farms are like, that's not going to fly. But technically, you can sue your parents. All right, just kidding, unless you were injured. So, and don't sue your parents. That makes family reunions awkward. Okay, so here's the Idaho-specific stuff that I love. So if you're under 16, Idaho says, and I just pulled this from the Idaho Code, you can't work during school hours unless you can read and write legibly and can perform simple arithmetic, including fractions. I love how like the Idaho legislators were like, let's make it tough. They have to be able to do math and fractions. Anyway, and in no circumstance can you work more than 54 hours a week. So yeah, this gets kind of interesting with child actors. It's why if you are making a movie with children, it will take longer to produce as opposed to adults, because kids are going to have this 54-hour cutoff where you don't have that with adults. All right, but again, that's your Idaho stuff. And then Idaho has a separate section for kids under 14. So they can't work in mines, factories, workshops, stores, telegraph offices. They really haven't updated this law in a long time. Laundries, those don't really exist anymore either. Restaurants, hotels, like they got so specific. I love it. Kids under 14 can't be wire walkers anymore. They can't beg or peddle as an acrobat. And I love this because I'm not sure if they mean they can't be acrobats, or they just can't, or they can't pedal, or they can't pedal as an acrobat. It's a little confusing here. They didn't bring their A game to this session. Or a contortionist, or for any obscene purpose. Again, very vague. I don't know what obscene means necessarily. And
could it be that they just couldn't do circus work?
Yeah, I think
entertainment?
I think that's the general idea here. Is if you're a 13-year-old, you can't join the circus. Like you can't run away and join the circus. So I tell my kids this all the time. And then finally, there's another section down at the bottom that says no minor can serve alcohol or work in a house of prostitution. And that's anybody under 18. So no serving alcohol, which many of you, if you worked at restaurants, the restaurant probably takes a great deal of effort, or takes, not a great deal, takes a lot of their time to make sure that you don't serve alcohol. And of course, I hope none of you end up in a house of prostitution, which I didn't even think those were legal. And I don't even know why that's a specific thing. Anyway, Idaho, this law was probably written a long time ago and just hasn't been updated. So, all right, houses of prostitution.
So, Brother Hales.
Yeah.
So you have the under 14 that can work for parents.
Yeah.
But then there seem to be a lot of stipulations that they can't work. So like if I own a restaurant and I decide to have my 13-year-old kid mop the floors or run the cash register because, you know, they're some math genius. Well,
they can do fractions.
Yeah, they can do fractions. Is that like not okay, or is it okay because I'd be their parent? Like,
that's fine. Kind of the major catch there is when you hire your child, it's just they can't do hazardous work, and that's a little vague, but I think we could all agree that hazardous work just means there's a high likely, or not even high, a likelihood of serious bodily injury or harm, something like that. I'm guessing is what the statute says, is how they define hazardous work. So as long as they're mopping and not serving alcohol, they can work in your restaurant. You just can't let them work 55 hours, and you better make sure they can read and write legibly, again, intentionally vague, and perform simple arithmetic. And then
so long as they were trained appropriately, would like a parent even be able to let them cook and be in the kitchen, or?
That's going to be a judgment call. And I think you've got a pretty good argument. They could work in the kitchen. Yeah, just keep those 13-year-olds out of the telegraph offices, and you should be okay. Yeah, I always love this. Like, I love Idaho. Idaho's a great place. All right, we won't even go into Florida. So, all right, next slide. So this is where we get to the wage and hour laws. Again, I just updated this right before class. It seems like every year it's Washington and California and DC are fighting to be the most progressive state here, especially as it applies to wage hour laws. So DC right now is the highest. They're at 14 hours, $14 an hour. But I think in like a week, DC goes to $15 an hour. So again, minimum wage in DC will be $15 an hour here very soon in 2020. California and Washington, they're currently at $13.50 an hour, although they are both scheduled to move to $15 an hour, if not this year, then next year. And again, that's statewide, which is interesting because, like I said, with especially Washington, you've got Seattle, and then you've got the rest of the state, which is basically Idaho, and yet the state minimum wage is going to be $15 an hour. So, of course, we're in Idaho, so we just stick with the federal minimum wage here at $7.25 an hour, and that's Idaho for you. Now, BYU Idaho does more than that. I think, correct me if I'm wrong, I think it's about $9 an hour that they start most people at school here if you're working for the university. Although if you work off campus, you could get a minimum wage job and they'll pay you $7.25. Now, because it's 2020, there's a lot of pressure for employers to increase their minimum wage. So I think Target just announced that they're going to $15 an hour for everybody. Once Target does it, you usually see this spread across other competing stores. They'll move to do it. Amazon has received a lot of pressure to move up their minimum wage, which they have done. And Walmart and others have done this. So finding a job that pays just the federal minimum wage can be a little bit difficult, simply because other chains and franchises and companies have just moved to on their own without being federally mandated or state mandated have decided to increase their minimum wage. So that's that. Overtime is important because there's a lot of confusion about this. A couple of years ago, my brother emails me, or he called me, and he's like, "Brother, I think I need to sue my job." And I'm like, "What?" And anyway, he was telling me how he works more than 40 hours a week, and he's not getting paid for overtime, and so he needs to sue his boss. So I calmed him down a little bit. I said, "Adam, what are you paid hourly or are you salary?" He said, "I'm salary." I'm like, "Okay. And are you considered a professional at your job?" He was in sales. And he's like, "Yeah, I represent the company in this, this, and this." And I'm like, "Okay, congrats. You're a professional, and that means you don't get overtime. Overtime typically applies to hourly workers who work more than 40 hours a week. And it's done by the week. It's not by month, like you don't add up your hours by month or whatever. It's done every week. So you may have overtime one week and not overtime the next week. It's again, for those that are primarily not in management, that's another key. And the statute describes it as this, kind of here in the middle of this slide. It doesn't apply to executive, administrative, and professional employees. All right? And professional is kind of vague. So I've worked at firms where the paralegals are classified as professionals. They're given a salary. And as a result, we could make them work very long hours and not worry about paying them overtime. Okay, so and of course, it doesn't apply to independent contractors, hence our lesson last week, just to get you understanding the difference between employees and independent contractors. Overtime laws don't apply to them. All right, the Family and Medical Leave Act, or what we call the FMLA. This is something that applies to companies with 50 or more employees. And for them, because again, we're not Europe, okay? Don't get confused on this on the exam. If the FMLA applies to you as an employer, then you have to give your employees up to 12 weeks of unpaid leave. All right, we're not France. You're not getting 12 weeks of paid leave. This is America. All right, so sure, we'll let you leave to have a child, to care for your sick parent, etc. But we're not going to pay you for it, at least under the federal regime. Individual companies change this all the time. If you go to work for Apple or for Google, even Amazon, you very may well have 12 weeks of paid leave to go take care of a child. Now we're giving time off to, and BYU Idaho is very liberal with this as well, and the church in general. When I could actually take, I think, paid leave if we had another child. Even though it wasn't me having the child, spouses get this paid time off as well with some of these companies. But remember, that's at the election of the company and not mandated under federal law. The federal law is unpaid leave. And again, it only applies if there's 50 or more employees. If there's a small company and you want to leave to go have a child or take care of a sick parent, let's use that. I may very well say, cool, you can go. And you're fired. And so again, the FMLA, just remember, it has those requirements there as well. All right, last-ish slides here. We're getting to the end. OSHA, this first one, the Occupational Safety and Health Act. This just means that employers have the duty to keep their businesses safe, to protect their employees from foreseeable harm. That's why OSHA exists. If you violate this, you could get an OSHA violation. You could be fined by the government and have to pay the medical costs of the employee that was injured on the job. Okay, so just quickly on that one. Here we've got state compensation, workers' comp. This is an interesting one because, again, workers' comp laws, I haven't practiced in this ever, but what I understand is quite interesting. If it's when you're injured on the job, even without OSHA being involved, if you're just injured on the job, your employer may have workers' comp insurance. And what happens is whatever the injury is, they've got a book of injuries and a dollar amount affixed to that injury. So if you lose your, this is what I love about it. I mean, it's so interesting. It's like, if you lose your finger, all right, if you lose your whole finger, it's like, well, that's worth $7,000, let's say. Like if you're injured on the job and lose a whole finger, you'll get 7,000. But if you only lose the tip, and they do this like by joint, if you only lose this top, well, that's only worth $1,000. And if you lose down to the knuckle, well, that's $4,000. And anyway, they've just basically priced out every part of your body to determine how much you're going to get paid based on the injury. All right. And so again, if you're injured on the job and they don't pay you, then you can sue them, you get a workers' comp attorney, and you get that amount because, again, presumably your employer has signed up for workers' comp insurance and is able to pay these out. They'll argue that you weren't injured on the job, there were pre-existing conditions, etc., and that's why you get an attorney to kind of argue, no, yes, I had a pre-existing condition, but I was injured on the job here, and it aggravated it such that I qualify for workers' comp, for example. Okay, and then and remember, all of this slide exists to show you that while we may not operate on a super liberal European model in terms of worker protections, there are a lot of worker protections in the U.S. And these first deal with injuries. The last ones here deal with unemployment and Social Security. Social Security, by the way, it's not just retirement. Social Security has an entire section dedicated for disability. So if you are working and sometimes not even if you're working, but let's say you're working for 10 years and you become disabled to the point that you're not able to not only do the job that you've always done, but you're not able to do any job. Let's say you hurt your back and you can't stand or sit for an 8-hour day. Well, if you can't do any job on a full-time basis, then the federal government will pay you Social Security disability for the rest of your life. Well, at least for the working life until Social Security retirement kicks in. So again, this is something that I did used to do. So I did used to represent people that had become disabled. They apply for federal Social Security disability benefits, and they deny everybody, usually. And eventually you get up before a judge. And when it's time to go before a judge, that's when I would come in, I would argue, I would have medical evidence and say, look, judge, my client can't work because he or she can't sit for 7 hours a day. In fact, they can't even sit for 4 hours a day. How are you supposed to work full time if you can't sit for that amount of time? And they can't use their finger, even though maybe they can sit, but while they're sitting, they've lost the ability to use their fingers because of carpal tunnel or whatever. Well, if you can't sit and use your fingers, what are you going to do? Like there's no jobs where you just like bang your head against buttons or something. You have to be able to use your fingers. And so anyway, if you get Social Security disability, you're not going to get rich. This is like a desperation move. Most Social Security disability recipients will make about $1,000, I think is average, maybe $1,300 a month. And that's what you get to live off of. Again, not great, but better than nothing. It'll keep you alive. And when you get Social Security disability, you'll get insurance as well. So Medicare is one of those, Medicaid as well. But Medicare is typically for the older population, Medicaid for the young and poor. FICA is how we fund all of these things. This is we'll get into taxes in a couple of weeks, but FICA it's one of those payroll deductions that you'll see, and you'll be so happy because you're like, you'll leave here and go work somewhere, and you're like, I made $4,000 this month, woohoo! And then you get your paycheck for $2,700, and you're like, what the heck? And you go through, and it's like FICA took out $600, and you're like, what is FICA? Well, it's just going to pay for these federal employment benefits, Social Security, unemployment, etc. Again, unemployment exists if you lose your job in an economic downturn, if you are let go as opposed to fired, then you can apply for state unemployment benefits. This is in the news lately because lots of people would like to be laid off because in many states, they're making more on unemployment benefits than they did while they were working. And of course, you've got legislators in the states and at the federal level trying to correct this. We've created incentives to not work as opposed to work, and that troubles some of our legislators. And then finally, we've got the ACA. That's the Affordable Care Act, or Obamacare as it's more colloquially known. We got a couple minutes here. Let me say this. Sometimes I have students that are concerned they can't find health insurance, and they say that they can't afford it. And I remind them the Affordable Care Act exists to help them. So the school has health insurance. And then last year we had that fiasco with like they weren't going to take Medicaid, and then they backtracked on that because of the pushback. If you apply through the Affordable Care Act, and this you just apply through the state exchange. So if you just Google like Idaho Healthcare Exchange or whatever, that's how our state has adopted Obamacare. You just put in your information, how much you make, etc., and it will say, okay, you qualify for subsidized healthcare, basically Medicaid, and then you go through that system. All right. So if you have more questions about that, why don't we talk about that after class? All right. But let me end with this, with employee privacy rights. This is important. This is in the news lately as well. What this means is that you have certain privacy protections while you're working. The key here is, did you reasonably expect to have that privacy protection that you're asserting? And for this, we're going to go back to, like, again, sorry, accounting majors, but we're going back to that reasonable standard. Would a reasonable person think that they had privacy rights in whatever it is that we're talking about? So it could be your computer system. When you got online and were Googling how to buy handguns rather than working, and then you got fired for that. Did you reasonably think that you could buy a handgun and have an expectation of privacy in your browsing history while you were working? Well, the courts have said no. Like if you're working on a work computer through the work network, you don't have an expectation of privacy because everybody knows that employers are like watching what their employees are doing. That's how we get all these studies about, workers spend 36% of their day on Facebook. Good gracious. Well, it's because they're watching you. Okay, so again, be careful there. On the exam, I talk about desks. So with the desks, what I'm looking for is like if the employer gives you a desk and says, here's the key, you're the only person with the key for this desk, do you have a reasonable expectation that that desk is private? You bet. So when they come in and do a random search for drugs or illicit or illegal whatever, and they find something in your desk, well, you've got a pretty good argument that you had reasonable expectation of privacy in that desk, and that therefore they can't come randomly search it. That's what I want you to remember about privacy. Okay, so let me pull it. Oh, there's some stuff in the chat. Okay, looks like we're good there.